Hello guys, my name is Afaq Ahmed, and today we will be solving problem question, and we'll also be studying regarding the problem question structure for the topic of trespass to person. As we have studied earlier, we have studied three topics of trespass, and number first was battery, number second was assault, and number third was false imprisonment. We studied all the elements of battery, assault, and false imprisonment. We also studied the definitions of it. We studied that battery is an actual infliction of unlawful force on another person. We also studied that there is no proof of injury required as it is the actionable per se crime. Then we noted down some important points regarding the directness and also studied the exceptions to it according to the cases of Purcell and Scott Shefford. Moving on, we went through intentions and we also noted down that there will be no liability of any offense which is beneath trespass to person where there is no intention. When there is no intention, there is no liability. And moreover, we studied that you must know the consequences of your acts. The actions which are you doing, you must know the consequences of it. We also noted the most important point that the actions you are doing must be voluntary actions. For example, you are hit by a truck and then you hit a girl. She gets injured, so you might not be held for battery here, as your actions were involuntary. Now, coming towards our topic, today we will study battery, assault, and false imprisonment structures. We will solve a problem question on it, and I will go through the most important cases for it, which can be used during this lecture and to solve your problems effectively. Coming towards our first problem question structure, keep in mind that first of all, coming towards battery, whenever solving a battery question, you must first of all define what is battery. Okay, you must give a definition of battery, which I already stated in the last lecture that it is the actual infliction of unlawful force on another person. Perfect. You should write this definition and also write that there is no proof of injury required. Proof of injury required. Perfect. After writing your definition, you must come towards satisfying the elements of battery. Like, first of all, you have to satisfy the intentional element. You have to state rather that from the actions of the defense person, it is clear that he was having an intention to cause injury or to cause harm to the person B. You may use the cases of Nash versus Sheen. Okay, these are the most important cases. I also stated a case in the last lecture, which is REF case. Okay, also use the case of friction. Note down these cases. These cases are present in the book and also in the lecture 1 slides. These are the three more important cases for battery, proving the intentional element of battery. Now, if you would like to guess what is in the case of Nash, so in the Nash case, it was written that the defendant's act were deliberate, even if the outcome had not been. You must look at the acts of the defendant. You must not look at that what type of injury is caused to the defendant. The main thing which matters is the acts of the defendant. Okay, the main thing that matters is the acts of the defendant, not the outcome. Okay, then we also studied a case regarding REF where it was stated that battery may constitute an intentional contact that was not generally accepted in ordinary conduct of life. For example, if a contact is out of daily conduct of life, then it is intentional. You must note down this point. Perfect. These are the two most important cases for battery. Now, coming towards a third element which we all studied there regarding the directness of battery. Okay. Now, in directness, we stated that the harm caused to person B must be due to the actions of person A. And we also studied the two important cases present on the lecture one slides. Note these cases: Purcell 1838 and Hasted 2000. The ratio of both these cases was same. Okay, both these cases clearly stated that indirect contact can fulfill the requirement of direct contact. As I gave an example of that woman holding a baby and a man pushed, wanted to attack that woman. However, the baby got injured. Would the person A be liable for the injuries of baby? A normal person would claim that he won't be liable as he attacked the woman, not the baby. However, if person A wouldn't have attacked person B, the baby wouldn't have been injured. Thus, he would be liable. You can use the cases of Purcell and Hasted, where you can clearly state that indirect contact of person A with B with the baby fulfills the requirement of direct application. Coming towards fourth element, you must state that there was application of force used. The most important case for this is Turner, which is present on in the book. Okay, Turner case. After satisfying all these elements, number first, writing the definition of battery. Number second, that whether it was intentional or not. Number third, whether it was direct or not, or any of the exceptions apply or not. Then after satisfying the element of application of force and writing down the case of Turner, you should come to the conclusion. If all these elements are satisfied, the person would be held for battery. Then you should apply any applicable offenses like consent offense, self-defense offense. These are the main, and necessity. You should use these of defenses, and by looking at the scenario and the facts and apply that one offense which is the most applicable at that present situation. So we studied this, and regarding the elements of battery, we studied, first of all, write the definition. Secondly, write that whether it was intentional or not, uses the case of Nash and Sheen, use the case of REF, and use the case of Frickson to prove that it was intentional or not. Then after satisfying the element of directness, using the case of Purcell 1838 and Hested, you can state that sometimes by looking at the situations or the facts, indirect contact can fulfill the requirement of direct contact. Then applying force, use the Turner case and conclusion, and apply the defenses. Coming towards the structure for assault. Same structure goes for assault. Few of the elements are same except reasonableness of fear and immediate nature. You should define assault. Definition of assault is present in the Collins case. Already I mentioned that definition in our lecture one slides. Okay. Then separate each element. By separating each element, it means that you should state that now I will prove the following elements of assault, which are intentional, direction, reasonableness of way, and immediate nature. You should state this. After stating this, you should state that now coming towards our first element, which is intention. Regarding the intention, you should use the case of R versus Ireland, the most important case. Okay. Here it was stated that silence, words, and threats could amount to assault when accompanied. This is the last point, is very important. When accompanied by a threatening gesture. Okay, use this case R versus Ireland for proving the intention. Now coming towards the second element, which is the directness, we also stated in our battery problem that you should apply the case of Hasted, that whether direct contact, indirect contact can sometimes fulfill the requirement of direct contact. And here you should use the case of George, Hasted. You can take it from the upper slides. Okay, Hasted case is the most important here. Then coming towards our third element, which is reasonableness of fear. Use the case of George 1840 and writes its ratio that a reasonable person in the victim position would have thought that there was a danger. Okay. Use this case and apply the facts that whether instead of person B, another reasonable person was there, he would also have thought that person A is attacking me and there is a danger of me being attacked. Okay. Use this case 1840. Then coming towards our last element, which is immediate nature. This is the most important nature element, sorry, and most of the time the examiners focus on this element. And the most challenging part of assault is this element. Use the case of Thomas. Use this case also, middle school, 2005, and prove that there must be an immediate danger of battery. As I stated in the previous lecture slides, that for example, a person A is having a stone and he's attacking on a person who is moving in a train, whether there is a chance of immediate nature of battery or not. From the present facts, there is no immediate danger of battery. Thus, the last element is not fulfilled, which is of immediate nature. Thus, the person A who is holding the stone would not be liable for assault, just because the immediate nature element is not fulfilled. And then conclude it and use the defenses. Coming towards last element, this is false imprisonment. Write the definition of false imprisonment, which was that there must be a total. Okay. Write the definition. I will only write the keywords: total, intentional, and unlawful. Okay. Constraint on freedom of movement of another person, but it does Okay, now coming towards our last offense, which is false imprisonment. Already studied in our last lecture that false imprisonment, let me give again, revise the definition of it, that it is the total. Firstly, it is the total. Secondly, it is the intentional. And thirdly, it is the unlawful constraint on the freedom of movement of another person. But it does not require any incarceration or the use of force. So thus, first of all, you should write the definition of false imprisonment, which I stated in the last lecture, and you can copy it from that. Yes, that is total, intentional, or unlawful constraint on the freedom of movement of another person. Perfect. So this definition gives now us three elements. Now, first is total, intentional, and unlawful constraint. First, you wrote the definition. Then go towards the Murray case. You should write that according to the Murray case, as long as the circumstances of false imprisonment exist, the victim does not even need to know that they or he or she is being falsely imprisoned. Okay, the important fact is that there is no need to be even aware of being false imprisoned as long as all the elements of false imprisonment exist. Then go towards the element of intention and prove that the person was having an intention and it was done due to intention. State the case of Iqbal, use the case Iqbal case 2009, and state that false imprisonment will only apply where the imprisonment was caused by the acts of the defendant and not that it was caused by the omission. You should look at the facts that whether the actions of the defendant were due to omission or whether it was done due to the defendant acts. If it is done by omission, then there is no intention and there is no false imprisonment offense. Then go towards the second last factor, which is total loss of freedom. State that the Bird and Jones case and the Robinson case, and you should claim that according to these two cases, there must be total loss of freedom. If you have a chance to get out of that place where you are being imprisoned, then there is no total loss of freedom, and the element is not satisfied, and there is no false imprisonment offense. Okay, this is the most important element, which is most most of the times focused by the examiner. This is the most important element, and all of the main problem is lies in this element. You should look at the facts whether the person is having a chance to get out of this imprisonment or not. If he has a chance, then there is no false imprisonment, just because there is no total loss of freedom. Then use the case of Bird, Jones, and Robinson. Then last element is unlawful, that whether the person who is being falsely imprisoned is done by the police or by the orders of the court. If none of them, then all other arrests, all other captivities, all other false imprisonments are an offense and unlawful. Thus, we studied false imprisonment. We studied that first of all, we will write the definition. Then we will use the case of Murray. We should also state the case that it was intentional or not intentional. We should then come towards the total loss of freedom. Again, is the most important element. I am again highlighting it. Then going towards assault, we first tried the definition of Collins versus Wilcock. Okay, important. Then we separate each element. For example, intention element, we state that island case words and threats could amount to assault when accompanied by threatening gesture. Then go towards the directness of element. Okay, use the case of hasted, and also state the exception that sometimes indirect contact can fulfill the requirement of direct contact. Then go towards this element, which is reasonableness of fear, and use the case of George, that a reasonable person, if in the victim position there is another reasonable person, would he have thought that there was a danger? If yes, the factor is proved. If no, the factor is not proved, and there is no assault. Then again, as I stated in the false imprisonment, that a total important element is the total loss of freedom. Here in assault, the most important element is immediate nature, and the whole problem lies in this element. If the danger is not of immediate nature, then there is no assault. For example, I gave an example of that person who is hitting a bus with a bus or a train with a stone, a moving train. Whether the passenger on the train would realize that there is immediate danger of battery or not. No, just because a stone cannot reach the train, a moving train, as there is no danger, immediate danger of battery. Thus, this element is not satisfied and there is no assault. Going back towards battery, you should first write the definition of the battery, already stated here, and also state that it is an actionable per se crime. Then you should also write that it is intentional. The main thing that matters is the act of the defendant and not the outcome. You should also use the case of REF and state that if the contact is out of daily conduct life ambit, then it is intentional. Then go towards directness, that whether the contact is being direct or not. State the exceptions if applicable. Use the cases of Purcell and Hasted. Then come towards application of force, Turner case, and conclusion. And if any of the three defenses are applicable, you must use those defenses to gain extra marks. Now we will go towards one of the problem question we will solve in step by step, and will apply these structures to that problem question. And now going towards that problem question now. Okay, this is the most important problem question. So the problem question is from 2023 zone A. Okay, let me zoom it a bit. I hope it's visible now. Let's start the problem question. Okay, reading the facts of the problem question. The Slogs are a retro 70s band who perform in local pubs and clubs at weekends. The members are Rian, the guitarist, highlight this one. Brad, who plays the bass, highlight again. These are the two most important characters. Then again, the Grass, the vocalist, and the Moni, the drummer. So we have in total of 4 parties here in this case. Moving on, one Saturday evening, Grace grows impatient with Brad and gently elbows him out of her way so that she can get to the microphone. Write down that the first relation is between Grace versus Brad. Okay, highlight that. Moving on, Bird turns and pushes her hard, causing her to fall and hit her head on Moni's drum kit. The second relation is between Brad versus Grace. Highlight it again and note it down. Then Aki, who is a keen fan of Grace, runs from the audience to help her, shouting at Brand that I will get you if you touch her again. Then the next relation is between Aki versus Braid. Note this again. Okay. Moving on, Aki trips over wire and crashes into Ryan, knocking him to the floor and breaking Ryan's arm. Again, the next relation is between Aki and Ryan. Aki then grabs Brad, leading him to backstage into the toilet and forbids him to leave. Braid has sustained a minor concussion and Braid has suffered attack of claustrophobia. This is the last relation with us. Now, look, the question states that advise the parties. Which parties are with us? We have four parties. Okay. Number first party is Rayan, the second is Brad, the third is Grace, and the last is Moni. Then we have also stated the relations between them. The first issue will be between Grace versus Brad. The second issue will be with Braid versus Grace. The third issue will be Archie versus Braid. Then fourth, Rian, and the fifth, Brad. Now coming towards our first issue, which is Grace versus Brad. Coming towards this fact, which is in pink color, states that Grace grows impatient with Brad and gently elbows him out of her way so that can get to the microphone. Now, look, gently elbowing a person means there is a physical contact between the two people. Thus, out of which three offenses, which one would apply? Either assault. In assault, there is no physical contact. Is there any false imprisonment? No, there is no total loss of freedom or anything other. The last element is battery. Is there a physical contact? Thus, battery will apply here. Apply the battery offense, then go towards directness. Okay, and state that whether the relation or the gently elbowing by Grace towards Brad is direct or not. Let me stay in the call. Perfect. Okay. Now, whether the relation between Grace and Brad and the action between these two, is it direct? Yes, it is direct just because there is no other intervening factor involved. Okay, write it down. No other intervening, pardon for spelling mistakes, intervening factors. Thus, it is direct. Now, coming to the next important element, which is intention. Now, you have to prove or you have to give two views in here. One should be against and one should be in a favor, and then conclude it. Like, first, you should use the case of REF, and you should state that it was the gently elbowing Brad, it is out of the daily life ambit, and thus there is intention. Then you should use the case of Turner, and you should state that no, it is in the daily life context just because the word gently has been used here. There is no hostility being done by Grace. Thus, there is no intention, and then conclude it. Okay, this tells us now we first studied that it's battery, then we studied that it is direct, then we studied two-way arguments for intention. First, we stated that it is out of daily life ambit, and then we stated that it does not have hostility, thus there is no intention. Now let's see what I have wrote here, going to the relation between Grace versus Brad. Applying the facts, Grave might be liable for battery against Brad. Satisfied. Battery is defined as an actual infliction of unlawful force on another person by keeping in view that it is action per se and does not require proof of damage or harm. Proved. I have proved that given the definition of battery, that it is an actual infliction of harm. Okay, battery definition given. I'm going step by step. Then I wrote that there are two requirements of battery. Again, step followed, and I wrote the case of Letang versus Cooper and stated that it requires an intentional contact. Moreover, the contact should be unlawful and there should be direct application of unlawful force. Thus, I wrote all the three elements. Highlighting it. Then, according to the case of Yorkshire, There is an implied consent to everyday social contact, and there are certain times where it is in public interest to allow anything other than touching a body is capable of being unlawful in absence of lawful excuse. Again, I used a case. Now, separating these two paras, why? The first para is whole about law. Now I am applying that law on the facts. Come on. Applying the facts, the elbowing by grave is covered by the daily social life contact, as in places and concerts. People elbow each other to reach the singer. Thus, the grave act of grave is not lawful, and there is an implied consent by bread, as they are both parts of the same brand. Thus, there is an implied consent in such circumstances where performance is done. Here I stated that these both are the members of the same brand and they have actually impliedly consented to each other during concerts. This is my first argument. Moving again, moreover, according to the case of REF, battery constituted any intentional physical contact. An important element is that it must be out of the daily conduct of life. However, I am claiming that the elbowing by grave is covered in the ambit of daily life conduct, and moreover, arguing that the case of, let me go down, Turner facts inform that the act was done gently and there is no hostility present here. Going back into the facts, let's again see here that it was done gently. Thus, there is no intention and hence one of the element is not proved and there is no battery and there is no offense committed by grace towards Brad. Your first situation is done. Going towards your second situation, which is Brad versus Grace. Okay, Brad turns and pushes her hard, causing her to fall and hit her head on Moni's drum. Let me check whether it is recording. Yes, this is the next case. Braid turns and pushes her hard, causing her to fall and hit her head on the Moni's drum kit. Just look at. No, I'm not going down. Okay. Use your mind. Which one of the three offenses is applicable here? Either false imprisonment. No, there is no imprisonment here. Secondly, assault. No, there is touching involved. Thus, it is battery. The offense of battery will involve. Going on into the elements. The first element is intention. You may use the claim that in the present, Grace was impassioned and she gently hated Brett with her arm. Thus, now Brett has an wants to take revenge from her, and thus he pushes her. Okay, this might be your argument. You can claim that there is an intention. Then coming towards the direct element, you state that there is no intervening factor being involved in these two actions. There is no other person involved, or there is no other action involved between Brad and Grace, as Brad pushed Grace and there is no other factor involved. Thus, it is direct and the second element is proved. Going to another element, unlawful. Whether it was unlawful or not, yes, pushing someone hard. Like in the first, we studied that it's someone gently, it is in the ambit of daily life. However, pushing someone hard, it is outside the daily life ambit. Thus, it is unlawful. Now conclude that Braid may be liable for battery in relation to Grace. However, now coming towards defenses applicable, Braid might use the defense of self-defense. However, you should write that we already wrote an argument that he did this only because of taking revenge. Thus, if you are claiming self-defense, then you should write that whenever a person is claiming the claim of self-defense or he is acting in self-defense, he should not use that force in revenge or retaliation. This is according to the case of Cockcroft. If a person is using that force for retaliation or revenge, as we studied in intention that he did it for revenge, the self-defense is not applicable. So now coming towards what I wrote in this scenario. In relation to Grace, Brad might be liable for battery. Battery is defined in actual infliction. Again, I wrote a definition of it. Then I wrote that there are two requirements of battery. According to the case of Litan Cooper, it requires intentional conduct and there must be unlawful and direct application of unlawful force. Now, coming towards that, I wrote the elements, then coming towards the first element, which is intention. I'm making it bold for you. You should write that according to the case of Wilson, a person must intend their act but does not need to intend the consequences of the act. Again, the first para is about laws. The second para is about applying the facts. Burdett turns and pushes her hard, causing her to fall and hit her head on the Moni's drum kit, and the facts clearly indicate that Brad was retaliating with intention and cause to harm. Moreover, retaliation to unlawful force, applying the case of Yorkshire, there is an implied consent to everyday social contact, and there are certain times where it is public interest to allow anything. However, after again using the law of Yorkshire that it is covered in a public interest and it is implied consent, you should again write this. Again, write your facts. That applying the facts, the Yorkshire case is not applicable just because the act of Brad is not covered under the ambit of daily life contact. Just because going again into the facts, look, Brad turns and pushes her hard. Thus, the case of Yorkshire is not applicable just because it is outside the ambit and it is unlawful to push someone hard. Thus, he or she would be liable for battery. Then, coming towards another important element, that moving on into the element of directness and causation, there are no intervening factors. And pushing her hard, there is no other intervening factor involved. Thus, the directness and causation is intact. You might use the case of REF and state that if the battery there is an intentional physical contact and it is not generally accepted in daily life, thus the person would be liable for battery against that. And also use the case of Rickson versus Star 21 and claim that if the act is done to get plenty of attention and was everyday conduct, then it is acceptable. Okay. Now coming towards self, any defense is applicable. As we studied, the braid might use self-defense. However, the braid might ask that she already elbowed me, and thus I use a self-defense and pushing her hard. However, applying the case of Cockcroft versus Smith, the force must be used in self-defense and not retaliation, and must be reasonable and proportionate to the threat by the claimant. This clearly states that, and we also stated in the above that the intention of Brad was to get revenge. Thus, however, according to the Cockcroft case, when there is an element of revenge, so the defense of self-defense is not applicable. Okay, and thus the defense will fail, and Brad would be liable for battery. So we did two situations. In the first situation, Grace wasn't liable, not liable. Okay. In the second situation, Braid is liable. It's because he pushed it hard. Now moving on, Aki, who is a keen fan of Grace, runs from the audience to help her, shouting at Braid, "I will get you if you touch her again." Again, the important factor. Coming to their relation now, let me make it visible for you all. The situation is now between Aki and Brad. Now let's see that whether she would be liable and whether which one of the offense would apply. Okay. Use your mind. Is there any false imprisonment here? Simple answer, no. Is there any direct contact or is there any physical connection between Aki and Brad? No. Which one then apply? There is a threat given. We already studied that when a threat is given, thus it is an offense of assault, and we have to prove that elements. Which offense will apply? Assault. Good. Define assault. That what is intention? Okay. Define intention. Then coming, I already stated that there is an important element of immediate nature. Whether there is an immediate nature, whether there is an evidence that now Aki would get and she will get her and she would get bread. Is there any immediate battery or not? Just because the answer is no, because she was in the audience, there would be a, about hundreds of people in that audience, which means that reaching her and getting her would not be immediate, and there is no chance of immediate battery. Thus, there is no immediate apprehension. Okay, element not proved. Thus, Aki wouldn't be liable towards Brad for assault, not liable. Now, let's see what are my arguments. Aki versus Brad, coming towards Aki versus Brad. Okay, let's see. Moreover, Aki might also be liable for assault by shouting at Brad that I will get you if you touch her again. Again, I wrote the definition of assault as according to the case of Gulf Collins by given by Gulf, that an act which is causes another person to apprehend the infliction of immediate unlawful force in a person. This is the definition. Note it down. Let me change the color for you. Oh, wait a minute, please. Okay. Then I wrote the laws, I wrote the definition, now I'm applying the facts. Applying the case of Thomas, 1996, there must be an immediate danger of battery. Moreover, according to the case of Mabasco, number 1 of 2005, the violence should be of immediate nature. These two cases again and again suggest that the violence or the battery should be of immediate nature. Applying the facts, there was no immediate threat by Aki, and moreover, especially Braid did not apprehend. Thus, Aki might not be liable for assault. Okay, so we are done with three situations. First, not liable. The second would be liable, and a third, again, not liable. Moving on. Archie trips over a wire and crashes into Rian, knocking him to the floor and breaking Rian's arm. This is the next situation. Archie trips over a wire and crashes into Rian, knocking him to the floor and breaking Rian's arm. Now look, false imprisonment apply? No. Assault apply? No, just because there is no threat given. So battery apply? Yes, you might apply battery offense. Coming towards the first element, is there any intention of Aki towards Rayan or not? No. Just because there is nothing, no evidence that Aki was having any intention or wanted to injure Rian. The only factor is that he just mistakenly tripped over the wire and crashed into Rian by negligence. Thus, it would be no intention here. Intention no. So Aki wouldn't be liable for Rian. No liability, not liable. Again, moving towards, sorry, let me note this. Again, towards moving towards the last situation, which is Aki then grabs Brad, leads him backstage into the toilet, and forbids him to leave. Important situation now. Let me. Aki then grabs Brad, leads him backstage into the toilet, and forbids him to leave. Which situation will apply? Look at this. Leads him backstage into the toilet and forbids him to leave. She is making a constraint on his freedom of movement and is asking him that you will not move from here. Thus, she is violating his right of freedom of movement. Which offense will apply? False imprisonment. Imprisonment. Okay, as she is violating his right. Now, you have to prove that whether there was an intention or not. Okay. Yes, you write that there was an intention in order to stop freedom of movement. Okay, to stop freedom of movement. Use the case of Iqbal, that it was Iqbal, and state that it was caused due to the defendant acts, thus it is intentional. Now coming towards the second element, which is total loss of freedom. Okay, whether there was a total loss of freedom or not, again make two-way arguments here. Use the case of Reed versus Coker and state that he was deprived of freedom of movement. Of freedom of movement. However, again, you should write two-way argument. Again, write the case of Bird versus Jones. I already stated this case that if you are having a minimal chance of leaving, then there is no false imprisonment. Write that he was having a chance to leave. This case or this fact now questions the element of intentionality and secondly total loss of freedom. Whether there was total loss of freedom or not, according to the Bird Jones case, no. Brad had already the chance to leave the washroom. As she already had forbidden him, she had not locked him, and Brad had a chance to leave it. Thus, there is no total loss of freedom, and Aki wouldn't be liable for false imprisonment towards Brad. Let's go towards my answer, what I wrote. Aki might be liable for false imprisonment against Brad. False imprisonment first comes with a definition. Okay. In condition of the use of force, more of the victim does not need to know that he or she is false imprisonment as long as the circumstances of imprisonment exist as discussed in the case of Murray. Again, I wrote the definition and then I used the case of Murray. Now coming towards the requirements. Following are the requirements of false imprisonment, there should be a total loss of freedom. Let me check. Yes. It should be intentional and unlawful. So first requirement is total loss of freedom. It should be intentional and unlawful. Second requirement, and unlawful. Third requirement. Moving on, proving the requirement of intention. According to the case of R.V. Governor, relevant intention is intention to detain. Moreover, it was argued in the case of Iqbal. Again, I wrote a case. False imprisonment will only apply where the imprisonment was caused by the defendant acts, not where it was caused by omission to act. Applying the facts, Akif took Brad to the toilet and forbid him to leave. This clearly shows that there was intention to restrain him from the toilet. However, according to the second requirement, again coming to the second requirement, the restraint or stopping freedom of movement must be of total nature and unlawful. According to the case of First in 2009, that is unlawful if you are having an authority given by the courts. It lies with the police. Akif was having no authority to restrain him. Thus, the act was unlawful. The second element is also proved. It was unlawful authority used by the Akif. Coming to the last requirement, that there should be total loss of freedom, because according to the case of Birds versus Jones, important case to be noted again and again, it is tested by the examiners. Imprisonment is a total restraint of liberty of that person, and not a partial obstruction of his will, whatever inconvenience it may bring on him. Implying the fact there was no total restraint on liberty, he was only forbidden and had a chance to leave easily the toilet. Thus, the third requirement is not fulfilled, and Akif might not be liable for false imprisonment. Here, we are done with an important problem and states that Akif might not be liable just because of a reason that the last element is not fulfilled, as he was having a chance to leave the washroom and there was no total restraint on his freedom of movement. This fulfills a whole problem question for trespass to person, and this might come in our exam point of view. If you leave battery and you use assault and false imprisonment, you cannot solve a whole problem. If you read battery and assault and leave false imprisonment, again, you cannot solve a whole problem just because all these three offenses are covered in one problem. And reading it conceptually, understanding and making in notes for it, solving problem questions for it will make you able to attempt a problem question on it. Use the cases again and also make into parts. Have a rough paper with you and make into parts which will be easy to you. By looking at the paper, you will be easy to write all the factors, okay? And this would make easy to attempt the paper. If you don't make it into parts, it wouldn't be easy for you to attempt it. And this is the end of our problem question. Again, moreover, we have no chance of highlighting it in a VLE exams. So thus we have only a rough paper. Okay, rough paper with you, and that rough paper will make you unable to make notes that the first relation is between which party. For example, the first relation is between Grace versus Brad, the second relation is with Brad versus Grace, the third relation is between Aki versus Brad, and the fourth is Aki versus Brad again. Making into parties and making the question into parts will make it easy for you to attempt that question. And directly attempting a question, it might confuse you again and again. Okay, thank you so much for watching this video, and hoping you will get a lot of marks in exams and good grades. Thank you all. Okay, now coming towards our last topic, which is trespass to land. Basically, there are two topics we studied. One was trespass to person, then we studied three subtopics under it: battery, assault, and false imprisonment. Now, coming towards trespass to land, let's dive into the question structure of how to attempt a problem question when it is regarding the topic of trespass to land. So, before starting a problem question, you must write the definition of trespass to land. As we already studied that it means enter unlawfully in other person's land or having an unjustifiable interference with possession of the land. This is a simple definition of what is meant by trespass to land. Okay, and in simple terms, it means when you trespass to someone's land unlawfully, or when you enter someone's land unlawfully and make any unjustifiable interference with anything or any possession of the land. Okay, then we come into the direct interference, which is the first element to be proved. You can use the case of Gregory 1829 in order to claim for the direct interference that you cause into someone's land, that is direct interference. Okay. Secondly, it must be voluntary. The interference must be voluntary. Like you can use the case of Stone was 1947. Okay, and stated that in this case, it was written that the defendant was brought onto the claimant's land against his will. This will not be a trespass. Just because when you bring a friend to someone's land without his choice or will, then it is not a trespass, just because it is not voluntary. Then we have the next requirement, which is that awareness of trespass is not necessary. Okay, the simple meaning of it is that trespass caused by a mistake is still actionable. Okay, this is a simple meaning of it. You can use the case of, let me write a case name, Conway 1951 and Beasley 1681. These are the two important cases in which it was written that in Conway it was written that someone who is mistaken as to their permission to enter onto land will be committing trespass. Okay, when you are in mistake that I have got a permission and you still enter without permission, then you will be liable for trespass. And now coming towards a second last element, which is no harm needed. It's simple. It means that it is actionable per se crime. Okay, this we have already studied for battery, assault. This we all studied. Then now comes this. For you point of view, this part of the question is one part. Okay. Now this is the second part. That who can sue or what is land? So basically, what is land? Any surface or permanently attached anything. Okay, permanently attached anything to the land like houses, walls, etc. It is included in land. Okay, so the basic definition is that, let me tell you the definition. It includes the surface and anything permanently attached to the land, like houses, walls, or standing crops. It also includes the subsoil, like the beneath soil, and airspace, which means anything above or below the land to a reasonable height or depth in relation to normal use of land. It means that anything on the land, anything beneath the land up to a specific depth, or anything up in the level of the land, like into a specific height, it includes the definition of land. Okay. Now, who can sue? The basic thing that someone having possession of the land. Okay. If a person is having possession, and secondly having exclusive possession, these two people can sue. Okay, these two people have, in order, if you are having no interest in the land, then you cannot sue. No interest in the land, not sue. Okay, now coming towards conclusion, you will then conclude that whether the elements are fulfilled or not. If the elements are fulfilled, you are good to go. And now go towards remedies. Now, there are two remedies available. One is primary damage. You are given damages if any damages are caused to your property or land. Okay, or injunction is given. Okay, nobody can. For example, someone is having work on your land, and they have brought escalators. So court will give you injunction, and those escalators will not work. Okay. Then coming towards defenses, if any applicable. First defense is permission or license. A person can claim that I was having a permission or I was having a license. Okay, that license or permission may be implied or express. The keys for that you can use is Wood 1845. Okay, so conclusion done. Then remedies and then defenses. You have two defenses. One is permission and license. You can state that I was having implied permission or license or express permission. Okay. Now let's go towards the solved problem of trespass to land. From the exam point of view, trespass to land is not important. The only topic which the examiner will cover is trespass to person, which we have covered in detail. So it is the most important one. Okay. Trespass to person is the most important. This we are doing only for the concept in case it is examined by the examiner. So this is a question on trespass to land regarding tort law. Now let's dive into the problem question. Paresh owns a farm in the country. Owns a farm. Let me highlight it for myself. Good. And the disused plot on the land in central London. Two things. One is disused plot and one is central London land. The farm is situated near to an airfield used by a gliding club. Okay. Some of the gliders have occasionally landed in the fields of surrounding farms, damaging the crops, but the gliding club has always paid compensation to the farmers in such circumstances. This is number one, is regarding the field. The plot of the land in central London, this is the first scenario, okay, make it first. The plot of the land in central London is adjacent to a building site owned by Bipin and on which he is building a new office block. The jib of tall crane constantly oversails into airspace above Parish plots. Bipin has offered to buy the plot from Parish, but Parish always asks for more than Bipin is prepared to pay. Okay, these are two situations here in which number first is damage of crops and then in the second day is the jib of the tail, a tall crane is oversailing into the airspace of Paresh's plot. Now, Paresh is now seeking to obtain an injunction, which we studied that it is a remedy against the gliding club, preventing it from flying over his farm, and against the developer of building site, preventing them from intruding into airspace above his land. Even though it will be very difficult for them to redevelop the land without doing this. Advise Paresh into any actions he may have in trespass to land. Now, coming towards our answer to this, Paresh should be advised that the trespass to land involves an indirect and unjustifiable interference with the claimant possession of the land. This is the definition. Okay. We first of all stated the definition. This is the definition. Okay. Then we studied that it requires there to be an intention, but the intention is to be entry into the land rather than intention to trespass. Therefore, as long as the entry was voluntary, the trespass can occur if the D was not aware of the fact. Use this case. So in the P's case, the D may have trespassed even if they have no intention to do so. Okay. So note this that he was having an intention. Now, as with all trespasses, trespass to land is actionable per se crime. Let me make him to stay into the call. Actionable per se, that is complete without professional proof of actual harm. Important point to be noted first. Coming again, in order to sue in trespass, it is essential to be in possession of land. Look at that. This is we already studied this. Okay. The facts of question tells us that B owns the land concerned. However, interest in the land without possession will not be enough to sue. As would be the case would be, for example, if Paresh had rented out his land. Referring to the facts, now I studied the laws that without possession there will be no enough evidence to sue someone. Then now I'm implying into the facts that one that there is nothing to suggest that he does not have exclusive possession of those properties and absence of evidence to the contrary. The owner of the land with the paper title demands to be in possession of the land. The fact that he does not live on the land does not matter, as he does not need to be physically on the land at the time trespass has occurred. Having established P right to sue will consider law. In this paragraph, we have stated that although he was having the title, he was a registered owner of this land. Then the point is that whether he should live on the property or not. So according to the Powell scales, there is no need to live on the land. The only thing that is needed to is that he should frequently visit the land and it belongs to him, thus he is having the right to sue. It is clear that now Paresh can sue the both companies. Now coming towards our first situation, which is the gliders. Paresh wanted to have an injunction against them, which is that to obtain an injunction to prevent the gliders flying over his hand, Paresh needs to establish that there has been interference with the airspace. This is our first requirement Paresh has to prove. In Kilson versus Imperial Tobacco, an overhanging advertising sign that intruded by no more than a few centimeters well above the sea roof was held to be capable of amounting to trespass. This is the very important case we have studied that once advertising sign was hanging and was intruded by a few centimeters and it was held as a trespass. Then in Liaquat versus Majid, a 75 centimeter projection, which was 4.5 centimeters above the sea ground, was considered a trespass, again in our favor. Okay. How in principle there is inaction. However, in these cases, the invasion was relatively low, height by fixture and not by aircraft or crane. Okay. Now we stated that in our facts it is very low. Then we again come to a case. In Burston versus Sky Views, it was held that there would be no trespass by an overflying aeroplane unless the plane flies so low that it penetrates the airspace at height, which could be thought to interfere with the rights of normal user of the land. Griffiths J. and Wilson concluded that there had to be a balance be drawn between the private rights of the owner and the interests of the public to take advantage of scientific developments in travel and communications. So this para is about whole. It is a ratio of the case and judgment remarks. Moving on. Therefore, an owner has rights in the land extending only to such necessary for the ordinary use and enjoyment of the land. As Burnton informs us that there was no trespass at height, therefore, regarding the gliders, there may be no trespass into airface. Like, it is clear that they haven't disturbed his right to live or freely on the land, and his rights are not disturbed, and he is enjoying on the land, thus, there will be no trespass. The situation might be different if, for example, the gliders who are taking method of taking aerial photographs of P farms may have a claim under the Protection of Harassment Act. However, the fact does not suggest this to be the case. Then we stated that however, if they were taking photos of his farm, then they could sue just because it is a harassment act. Paresh may have more success in election for nuisance. However, even if nuisance took place, the court is likely to be balanced the social value of the gliding club with the need to protect property. We will study nuisance in detail. Now, coming to the second situation, which is that the jib of weapons crane will intrude piece is spaced at a lower level than the interfere with the rights of normal use of the land. We just studied that whether the piece is spaced at a lower level than the gliders, but does interfere with the normal use of land or not. The question is this: in Anchor Brew House development, this is the case. Note it down. Anchor Brew House Limited development. The D company had sought to argue that their claims which overhung the seized land were not a trespass just because of the public interest in developing a major site in London and the unreasonable cost to them of reciting them and constructed a building with a smaller footprint. It was held that the decision in Burston Sky Views had not altered the law, so that where there was an invasion by a structure adjoining the land of the sea, there would be a trespass. The D was taking into possession, no matter how briefly space it was entitled to reduce actual possession. Therefore, no scope for balancing interest in the way adopted in Burston, since the case was concerned with the protecting the interests of a society at large rather than of individual airline operator. According to the case, invasion of B screen will amount to trespass just because, like we studied that if it is the crane was in public interest, the building of that building was in public interest, then it would not amount to trespass. However, it was already in interest of an individual airline operator. Thus, it would amount to a trespass. Now, coming to any defense, will B be allowed to a defense like Bipin can raise a defense or not? Let us study that. The court may take an order allowing for reasonable excessive work to be performed for the purpose of preservation of adjacent land. The act does not apply to work for the alteration and so forth, since V is building something completely new, so he cannot take advantage of anything as such. Normally, injunction will be granted subject to the normal equitable rules such as the behavior of C. He must not, for example, have encouraged the D to believe that work has been permitted nor has been delayed. Let's note this case first of all. Let me change the color. An injunction to restrain a developer from trespassing with a crane was suspended for such time as effectively denied the remedy to a C which had been adopted a wholly unreasonable attitude towards consenting the aerial invasion. However, this approach has been disapproved in several cases, including Anchor Brew House. This case was confirmed that C was entitled to an injunction as a matter of house course of the trespass was going to be repeated. It does not seem that the C might be acting it accordingly. However, B might be like in the first we stated that C that in the first situation we were having the gliders clubs, so they may not use the defense of injunction. Then we studied that Bipin may argue that damages would suffice. The general principle governing the grant of damages was set out. This is the law which deals with the law of damages. This case deals with damages. These were that the injury to C right is small. The injury can be estimated in financial terms. The injury can be adequately compensated in money terms, and it would be oppressive to D to grant an injunction. However, in infield case, it indicated that damages should be calculated to reference to all the factors. In case D had benefited commercially from the use of land for advertising purposes, then commercial profits to be made at developing might be equal to a substantial sum. Okay, thus we stated that the first will not have any injunction, and the second one, Bipin can have may argue that for some damages, and that damages would be compensated in money terms. Okay, this was a whole problem for the trespass to land. First we studied that definition, then we studied that who can sue. Okay, then we studied the full situation of gliders, then we studied the situation of crane, and then we dived into the defense applicable, and after that we came into the remedies section. Thank you for watching the lecture and hoping you will get good marks in exam. Thank you.